Welcome back to Chapter 6 of the Module 5, Rules and Regulations for Financial Advisory Services. Now, the last time we broke off was when I was dealing with the PEPs under paragraph paragraph 8.5. This is regard to the financial advisor determining any natural person appointed to act on behalf of a customer or a connected party of a customer is a PEP. Right? If the financial advisor decides that that natural person is a PEP, then the financial advisor will have to conduct ECDD. If you look at 8.5.1, so the acronym used there is ECDD. Which means enhanced customer due diligence. Now, 8.5.2 tells you about the necessity for a financial advisor to check whether a person is a PEP on a commercially available databases. Right? This includes your Reuters, your whatever commercially available databases on the internet. I'm sure your companies would have subscribed to some of these databases, right? The minute you type in the name of the person, then if the person is a PEP, then the name will pop up, right? And furthermore, the financial advisor is to get the customer details, like occupation, name of employer, and other types of information that may or may not be available on the public websites. So what is required for the financial advisor is to exercise sound judgment, right? They leave it open. So the financial advisor must take reasonable basis in order to be able to exercise sound judgment in identifying whether a person is a PEP or not. So 8.5.4 tells the financial advisor in terms of the information sources whereby the asset and the income declarations can be inspected, right? Can be obtained from the customer in order to determine two things. One is what we call the source of wealth, all right? And the other one is known as the source of funds. Now, I've alluded to this earlier in the earlier presentations to you under this series. Now, here the guideline gives you greater details, give you more meat, as it were, more substance, for you to be able to understand the meaning of source of wealth as distinct from source of funds. All right. Now, 8.5.5 says clearly that it refers to the origin of the customers and beneficial owner's entire body of wealth, meaning to say that person's total assets. Right? This relates to how that customer or that beneficial owner have acquired their wealth. So here we're looking at the acquisition of health. Right? How this person acquires the wealth over time. Right? So, meaning to say whether the wealth comes from inheritance or come from other origins where the wealth has been acquired over time. Right? Source of wealth information gives the financial advisor a clear indication about the size of the person's wealth. And so how the customer and the beneficial owner acquire that wealth. So the emphasis there is acquisition. Right? So the notice provision says that it may be possible to obtain general information from the customer himself or herself. Either the natural person who's the customer before you or the beneficial owner that the customer is acting on behalf of. And here again, they refer to commercial databases or other open sources. Right? There's a lot of information which are provided by commercial databases. All you need to do is to subscribe to this, and they are made available to you. So the evidence that will relate to the source of wealth may include information and documents as evidence of title. Okay, meaning whether there was a will or there was some inheritance, or whether there was a trust deed, any other audited accounts or statement of accounts, bank statements, and so forth, right? Which enable the financial advisor to track back, to trace back how this particular person acquires the wealth. All right. So we more or less know that some of the rich people out there, they have inherited their wealth over time. All right. It is probably a legacy from the patriarch that has gone past generations ago, and there's a trust there, right, for people, for the generations that come after this patriarch. So how this person acquires the wealth over time can be evidenced by trust deeds and other types of documents. Now that is the meaning of the source of wealth. Okay, we are looking at acquisition. Now if you look down at 8.56, here there's a phrase called source of funds. All right. Now the source of funds refer to the origin of the particular funds. Now this is origination, right? Of particular funds or a particular body of assets, which are the subject of establishment of business relations. Example, the amount being invested, okay, in a universal life policy or in a collective investment trust, collective investment scheme, a CIS, or other deposits, right? So here we are talking about the funds that are coming in and where does the origin of the funds come from. In order to ensure that the funds are not proceeds of crime, right? So here we are talking about money laundering. We are talking about terrorism financing, right? So when the person puts in money, buys a product, so where does the source of funds come from, right? So this is different from source of wealth. So the financial advisor should not limit its source of funds inquiry. So to identify the other the other FI from which the funds have been transferred, but more importantly, the activity that generated the funds. All right. Now, this is to address the issues of layering, as we have discussed earlier. All right. So the placement of funds, then the layering of funds. So the money launderers and those people who finance terrorist activities will tend to layer, to do layers on transactions, right? So therefore, you need to trace where the source of funds originated. So that's the meaning of source of funds, right? So I read to you that important line there. The information obtained should be substantive. All right. It is not just a touch and go basic kind of inquiry, but it must be substantive, right? To prevent money laundering, it is key to be able to identify where the funds originated. And here they provide you with examples of appropriate and reasonable means of establishing the source of funds. Well, they look at salary payments, sales proceeds. Here, sales proceeds, we are looking at, for example, let's say a person comes before you and wants to buy a property, all right? Say $2 million or $3 million, a piece of property. But if we can show that I've sold another property, a previous property, to a tune of say 1.5 million, then I guess it is all right to say, hey, look, this guy has the money, to buy another property or to invest in some other assets, because the source of funds come from the sale of his previous property, right? So that can be a preliminary kind of inquiry to see where the source of funds come from. But of course, that doesn't prevent the financial advisor from looking back a little bit further to see how he has funded the first purchase of his property or other assets. So therefore, the key is still the same, in that sound judgment must be exercised by the financial advisor in assessing the source of funds. Right? So 8.5.7 emphasizes the point about risk assessment, the risk-based approach of a PEP. And here it highlights the fact that the financial advisor should consider whether the information regarding the source of wealth and the source of funds should be corroborated. Right? There could be some corroboration between where the funds are being acquired, right? The acquisition of the funds and the origin of the funds. Okay? Now, here they look at, and give another example there. Appropriate and reasonable means for establishing the source of wealth or the source of funds are financial statements of a legal person or legal arrangement owned or controlled by a PP. That's one. Looking at statements made by them, or site visits, right? I mentioned that earlier to you. Site visits are important if you really want to go into the details. Visit the customer, have a chat with the beneficial owner if you can establish the beneficial owner, and go to their places of business or residence or whatever, and try to find out for yourself, right? Because by having site visits and face-to-face, sometimes it's easier to look at body language and look at what the customers say. And if you have prepared piercing questions, as it were, inquiry questions, then you may be able to discover more about the particulars of a particular investor or a particular person. Or you can look at a copy of the will, as I've said earlier, in cases where the sources of wealth or source of funds is an inheritance. Or if there's no will, you can look at the letters of administration. Sometimes people, especially the older folks, normally they have a trust. All right, look at the trust deed. Right, if there's no will, maybe look at the intestacy testaments. Look at the administrator and see how the statement of affairs of the deceased person is, and then to establish the source of wealth or the source of funds, whatever the case may be. Or, and as suggested to you, also conveyancing documents. Here we are looking at sale of properties in the past, and there are conveyancing documents that will document how much money the property has been sold, and therefore you can establish substantively, right, the amount of money that person has from the sale of a property or the sale of some assets or some shares in the company that person may have. Okay, so that covers, in brief, sources of wealth and sources of funds. Okay? Now then, if you look at 8.5.8, here they are looking at the other enhanced customer due diligence measures to include the first payment to be carried out through an account in a customer's name with another FI subject to similar or equivalent CDD standards. Right? And also using public sources of information. We have talked about this to gain a better understanding of the reputation of the customer. All right. Sometimes if you were just to type your name on your mobile phone or on your PC or on your laptop, you will find details of a person's name pop up. All right. For example, even if you type my name there, it'll pop up to tell you that I'm a lawyer, I've been a director of a company, and so on. So the reputation of a customer or a beneficial owner can be obtained through the internet, either Google or what have you. Okay. All right. So if the financial advisor finds information containing allegations of wrongdoing, dishonesty, etc., then the financial advisor should assess how this affects the level of risk associated with the carrying out of business relations with that particular person or persons. Right? And if need be, underline 8.58C, commissioning external intelligence reports. All right? This is something additional and maybe costly. All right? But if the client is big enough, as it were, then it may be worthwhile to commission an external agency to give you an intelligence report. All right? Where it's not possible for the financial advisor to easily obtain information through public sources, or we have doubts about the reliability of public information, right? All right, so to engage some private agencies to do a check. In fact, for myself, I've done that as a lawyer. I've done checks with customers who come from Thailand and from Taiwan and elsewhere, right? So you have in doubt, get a law firm or get an accounting firm, all right, to do some checks of these persons in the foreign jurisdictions. Right? Especially if your customers come from a foreign jurisdictions and they are PR or under some work permit in Singapore and want to invest in some other products here. Okay? So that is the extent in which this notice requires a financial advisor to do the enhanced customer due diligence. Okay? Now, then they give you, of course, a qualification, the 8.5.9, right? So if you, in relation to the what we have said earlier, so if the financial advisor assesses that the business relations with a domestic PEP, right? Domestic PEP means some ministers or some senior judicial officers, senior military officers, etc., political party members. Then if the FAA, the financial advisor assesses that these people, the domestic PEP or the international organization PEP, like from the World Bank or the United Nations or from the Asian Development Bank, etc., if they do not present higher the MLTF risk, therefore the enhanced customer due diligence measures need not be applied. Again, as I said, this is a judgment call, right? So you do your own assessment and you think that, hey, that's not necessary because it is a domestic PEP, all right, a member of an international organization that you feel is above board, all right, it's a judgment call, then perhaps there's no need for a financial advisor to perform the enhanced customer due diligence. However, where changes in events, circumstances, or other factors lead to the financial advisor's assessment that the business relations or the transactions with that particular customer presents a higher the MLTF risk, then you should review its risk assessment accordingly and then apply the ECCD measures. Okay, so on the one hand, they say, look, you need to do inquiry. And on the other hand, the FAA notice say, look, if you think that there's no necessity in relation to a domestic PEP or a person related to an international organization, then, well, you do not need to do the enhanced customer due diligence if the financial advisor considers that it is not of a higher risk in terms of money laundering or terrorism financing. Now, then 5.510 says, while domestic PEPs and international organization PEPs may be subject to a risk-based approach, it does not preclude such persons from presenting the same risk as a foreign PEP. Right? So even though they are local domestic PEP or a member of a senior member of an international organization, well, if you think there's a need to do the ECDD, please do so. Right? Because performing ECDD can be a costly affair. And it may not be worth the financial advisor's time and money to do so. Right? Okay, then let's move on. So the next paragraph talks about whether you need to do the same enhanced customer due diligence when a PEP has stepped down from a prominent public function is a relevant factor. All right, this senior judicial officer may say a high court judge or a judicial military officer, say a brigadier general person of a high-ranking person. This person has already stepped down, has already resigned, has already retired, whatever the case may be. Then this stepping down, the financial advisor, does it think it necessary to continue to perform the enhanced customer due diligence, right? So again, it's a judgment call on the part of the financial advisor in determining whether that is a relevant factor. Having stepped down from a prominent public function, in determining the influence that the PEP continues to exercise. I believe I mentioned that earlier before in passing. All right. Let's say a retired high court judge, a retired brigadier general, right? Or retired minister for that matter, all right? So once this person has stepped down from a prominent public function, a high-ranking person, very prominent public function, so that this person continues to exercise that kind of influence in order for him to be, for the financial advisor to do the enhanced customer due diligence. Okay? So other risk factors involved should be seniority of that person that the individual previously held when he was a PEP. So how senior was he? Okay, and whether the individual's previous PEP position and the current function. All right, so this retired senior PEP could be appointed as a director somewhere or an independent director somewhere or some other position. So whether the current function are linked in any way. Example, whether the ex-PEP was appointed to his current position or function by his successor, or whether the ex-PEP continues to substantively exercise the same powers in his current position or function. All right. So what kind of influence has this retired PEP from a prominent public function has? Okay, his seniority at his old post and the current position. Right. Right. For the avoidance of doubt, I guess it is if that person is senior enough, that even though he has retired or resigned and he holds some other position, right, that person, in my own view, my personal, is good, is prudent for the financial advisor to conduct enhanced customer due diligence. All right. In any way, this person is still considered a PEP. Okay. So I think we have done enough of this PEP and the need to do enhanced customer due diligence. Now moving down to 8.6, then the FA notice number 6 talks about the other high risk categories. Alright, so here I do not want to belabor the point. So if you cast your eye down the page, 8.61 all the way down to 8.66, right, you will see the definition and the scope of these other higher risk categories other than PEPs. Okay? Right? And I just want to refer you to 8.6.3, right? That the financial advisor should refer to the FATF public statement. Underline that one, right? So there's a statement by the Financial Action Task Force, FATF, Financial Action Task Force. All right, this organization, this international body, issue a public statement on high risk and non-cooperative jurisdictions, on which the FATF has called for countermeasures. Right, we have mentioned that before. And you look at down the page there under subscript 3 below, they give you a website, right? So if you go to that website, under that particular website, then you can see the statement relating to high risk and non-cooperative jurisdictions with the FATF. Right, as we have defined earlier from the start of this particular chapter, the FATF is the international body, right? Setting standards for anti-money laundering and against terrorism financing. Okay? So that statement is important for financial advisor to take a look at. Now then, if you look at 8.64 for higher risk business, all right, so 8.63 refers to non-cooperative jurisdictions. 8.64 refers to the business of a particular customer before you, which inherently presents higher MLTF risks, right? And here it refers to sound practices highlighted in the MAS information paper. So here the MAS also has a paper that says guidance on private banking controls, right? So as you may or may not know, money launderers or people who finance terrorism sometimes do resort to private banking or privileged banking facilities. All right, these are high net worth people. All right, so they make use of private banking, they make use of privileged banking, all right, in order to place out their illegal funds, funds from criminal activities. All right, and as a result of which, MAS has issued this particular guidance on private banking controls. Now, there's also a link for you to look at below that 5. That's the paper that has came up in 21.4 about private banking controls. And below that, under A to D, they gave you some guidelines to ensuring that information obtained on the source of wealth of the customers and beneficial owners should be, underlined this one, independently corroborated against documentary evidence of public information sources. All right. So it is a repeat of what we have said earlier, source of wealth. So where does this customer, where does this person, all right, acquire the wealth from? Inheritance, all right, under a deed or under a will or under whatever, all right? So you need to corroborate, all right, double check, double confirm, to say it colloquially, all right, independently corroborated against documentary evidence or public information sources. All right, party screen should include operating companies and individual benefactors contributing to the customers and the beneficial owners' wealth and funds. All right, sometimes this may refer to some charities or some religious organization, right? All right, where people ask for donations and so forth, right? Or people who are contributing to some of these funds. Okay, C, financial advisor conducts periodic reviews of such customers, right? Periodic reviews, and when the financial advisor is aware of customers having a common beneficial owner, right? Many sources of transactions, many types of transactions, using different types of customers, but the ultimate beneficial owner is the same person, right? That causes for suspicion. Or when a customer has multiple accounts with the financial advisor, okay, then the financial advisor should scrutinize transactions of these customer accounts holistically, all right? So look at the whole picture, not just independent, separate accounts. So on the entire basis, on a holistic basis, to better identify whether these transactions are suspicious. All right, we'll come to suspicious transactions a bit later. Usually large or unusual patterns of transactions or frequent transactions or changes in the pattern or the manner or the way of transactions, right? So the financial advisor must be able to identify the separate dealings, particularly separate complex dealings of a particular customer, right? Where net the beneficial owner is the same customer, the same beneficial owner, right? So whether these are varied and frequent and separate transactions on the whole basis, on the entire basis, on the holistic basis, right? Give any reason for the financial advisors to say that these are suspicious transactions, right? Okay, so let's move on. And 8.6.6, I'm going to highlight to you, especially look down the third line there, whether the customer's assets are proceeds of serious crimes, right? Including willful and fraudulent tax evasion, underline that. Right? So tax evasion has become a very, very serious crime under this particular notice. Right? Tax evasion is corruption, and it is quite prevalent in many jurisdictions, especially jurisdictions that what the FATF considers as non-cooperative jurisdictions.